marks question, only 2 line. 2 marks question, only 2 line. Within the criteria of section 32, Ontario government is bound by the charter. That's it. Do not write rule application because 2 marks question. If question gonna come from a exception, then we have to go further. 10 marks question. Okay, issue rule application conclusion. Room 1 is done. Then room number 2, freedom of expression. Okay, in freedom of expression. Okay, my porno, I have to publish, printing. I have my freedom of expression. I have to freedom of expression. Again, I told you every time, room number 2 is always going to be infringed. Just to tell to the examiner, just within the criteria of 2B, R1-2I. There was a case 2B, R1-2I. Do not write even I have everything. R1-2I. Only 1 page. Only 1 page. That's it. Okay. See, there was a conclusion. 2B, just to tell to the examiner, within the criteria, there was 2-part test. There are 2 tests. Do not write. Does the activity convey a meaning in a non-violent form? If there was a rule, I pick up R1-2I, I pick up from R1-2I. Okay. Does the activity convey a meaning in non-violent form? If so, purpose or effect of the law to limit that type of expression. This is a rule. Rule, cut, copy, paste, rule apply into the application. What is the first rule? Does the activity convey a meaning in non-violent form? Mark my words, non-violent form. Violent form is only one. Kill them, kick them, beat them, punch them. These are only not covered. If I'm gonna say Muslim people are terrorists, do not take me wrong. I'm just giving you example. Okay, do not take me wrong. I'm also Muslim too. Okay, do not take, I'm Hindu, Sikh, everything but do not take me wrong. I'm just giving you example. This is my freedom of expression. Okay, in non-violent form. According to my opinion, okay, Holocaust. I'm against the Holocaust. This is my freedom of expression. But Holocaust is, especially in Canada, is very sensitive issue. But point to be noted, tell to the examiner, I know some of the form of expression contemplate within the provision which do entail violence. There was some violence which does not cover under the 2B. But in a given scenario, only making a porno does convey a meaning in a non-violent form. So first step has been established, right? Expression to making a movie, publish in a non-violent form. Violent is only kill them, beat them, kick them. Did I say anything in a given scenario? Right? 2B is very good. 2B is going to be infringed. Okay. Then second step, purpose or effect of the law. Who is making purpose or effect of the law to limit that type of expression? Limit. I mean, point is the guy, you are making a movies and you were grabbed by the Ontario government. Okay. And 12-month jail. 12-month jail you are. Now you are here in a court. First question, whether charter apply to the Ontario government, issue rule application conclusion. I'm a judge here. Very good. 2B, you already, okay, 2B, your 2B is going to be infringed because you are making a movie. Okay, doesn't matter play TV or whatever, right? You guys are making. So issue rule within the criteria of R1-2I. Rule is, does the activity convey a meaning in non-violent form? Cut, copy, paste. Rule is like a Quran, Gita, Bible. Then the purpose or effect of the law to limit my freedom of expression. Yes. Purpose or effect of the Ontario law is to limit my freedom of expression by putting me behind the bar for 12 months. There was a severe limitation on my freedom of expression. If I'm going to use my freedom of expression, first of all, it was a non-violent form. Then rule number 2, purpose or effect of the Ontario law to putting me behind the bar for next 12 months. There was a serious violation of my freedom of expression. 2B is done. 2B is done. Prosecutor. Now jump into the prosecutor. Issue whether law is justified under section 1. Ontario government prosecutor, whether law is justified under section 1. Rule, sufficient important objective, rational connection, minimum impairment, proportionality effect. Rule, cut, copy, paste. Rule apply into the application. Sir, what is your sufficient important objective? He has a freedom of expression, making movie, publishing. He has a freedom of expression. Federal government cannot make any law which is against our freedom of expression. You are Ontario government. Why did you make a law? What is your sufficient important objective? Why not he cannot use his freedom of expression, man? He has a Canadian constitutional status. What is your sufficient important objective? Tell me. Otherwise, law would be stuck down.
To protect women.
Very good. Very good.
One reason can be that it objectifies women. That can also.
Okay. So can you read? Okay, ma'am, can you read first paragraph again? Sufficient important objective. Huh? Sufficient important objective. Can you read? We're gonna pick up from the given scenario. What is sufficient important? Can you read?
Sir, we don't have this.
Oh, sorry. Can you read? Okay, he's gonna read.
Where am I reading again?
First paragraph.
First paragraph. The Ontario government enacted the Ontario Anti-Pornography Act 1988 in response to the lobbying efforts of two broad-based coalitions, the Coalitions for the Advancement of Gender Equality and the Coalition for a Return to Traditional Values. The Attorney General had been concerned for some time that the obscenity provisions of the criminal code did not provide sufficient protection for women from the harms caused
sufficient protection, sufficient important objective to protect the woman from the
harms caused by
this is a sufficient important objective. Study shows again, what is a sufficient important objective? Protect the woman
from harms caused by pornography.
So that's why we are limiting your Charter of Rights. Sufficient important objective. That's why we are limiting your Charter of Rights. I'm a judge here, sir. I agree. What is your rational connection between the objective? Again, objective is protect the woman, which is racially connected between the objective and discrimination. You were being discriminated because there was a racial connection between the objective. Objective is again to protect the woman from the harm which is racially connected. Minimum impairment. What did you do for minimum impairment, prosecutor? Use your brain.
Under 20.
Again. Yes, beautiful. Minimum impairment, exactly. The minimum impairment mean, if you, for example, if you are confused in minimum impairment, do not waste too much time, because minimum impairment just only 3 marks, 2 or 3 marks. If you're gonna waste too much time, because section 32, we all people are in the same room. 2B, we all people are in the same room. Section 1, sufficient important objective, issue, same rule, same, we are in the same room, rule, issue, 4 step, then application, issue, rule, application, sufficient important objective, same step, always yes. How are we gonna get marks? Trying to save the time. Rational connection, minimum impairment, if you are confused, if you're gonna go, oh, there is no minimum impairment. If you are confused, there was a lot of minimum impairment. What difference? Only 3 marks difference. You're gonna get 0 out of 3. 0 out of 3. Rest of everything's done. How to present minimum impairment? Now you can use minimum impairment under the age of 21 or under the age of whatever minimum impairment. So don't worry about minimum impairment. The point to be noted, do not focus on because minimum impairment is very heart and soul. For example, minimum impairment, in order to establish minimum impairment, hire another lady, which is called minimum impairment. Here, do not porno. If you think there is minimum impairment under the age of whatever, there is no minimum impairment, or again, minimum impairment, porno is minimum impairment. What can be a minimum impairment? Which way you can go? It's total up to you. You can say in a given scenario, porno is not a fundamental right. Porno is not a fundamental right. It means we don't need to be established to minimum impairment. This is not your fundamental rights. Porno is very third class act. Okay, and there is no, you do not have a fundamental rights. We are not trying to stop to drinking of water. We are not trying to stop the admission into the university. We are not trying to stop whatever you have a fundamental rights. Porno is not your fundamental rights. Itself is a minimum impairment. Right? Okay, one more question. Just I need your eye contact. Just 2 or 3 minutes. I need your eye contact. City, a computer guys, I need your eye contact, please. City is making a law. Who is making a law? City. in any major intersection